Hi everyone. Today's unit that we'll be doing is contract law, and my name is Shazia Khan. The learning outcome we'll be doing today is to understand contractual terms and exclusion clauses. So firstly, what I want to do to just summarize what we did in the last session, which was learning outcome 2. So in learning outcome 2, we looked at understanding the key elements of a binding contract. We looked at 2.1, which was to distinguish between an offer and invitation to treat. We then went on to look at what an offer is. So it's a statement of terms with the offerer so that the prepared to become a binding contract. We looked at the termination of an offer. So an offer may be terminated if the offer is withdrawn or revoked, or the client making the offer dies, failure of a condition, or reasonable period of time has elapsed, so time limit. We also looked at acceptance, where if an offer is accepted, then acceptance is the final term of the offer. We then went on to look at invitation to treat, so how that is different from an offer, where it only invites the party to make an offer. And we gave the example of someone who's selling a flick knife in a window, or things like if they're inviting you to get that flick knife, and the case of that important case was Fisher and Bell in regards to that. We then went on to look at the difference between an offer and acceptance, where an invitation to treat is where the client invites you, as I've just said, to make the offer, for example, a job advert or internet newspaper. Offer, on the other hand, is when the client offers the job to you without advertising it. We then went on to look at 2.2, which was to look at the issues regarding the postal rule and why that is important and how it's created, and when it becomes a contract in regards to postal rule. We also looked at face-to-face situation. Business parties can communicate if anything occurs. We also looked at the postal routes with reference to case law. We looked at issues in regard to how postal rules should apply to things like, where there's a contract in regards to emails or anything like that. We then went on to explain 2.3, explain consideration, the rules of consideration and test for enforceability. And we looked at what the basic rule is in regards to consideration. We looked at cases such as Adam and Linsell, 1818, Howell Securities. We then went on to look at the common definition of what consideration is. And we looked at a famous case which defined what consideration was, which was the case of Curry and Misa, 1875. We then went to look at the requirements for for consideration to be valid. We looked at cases in regards to that, such as consideration must not be in the past, and we looked at the case of Roscola and Thomas. We then went on to look at one of the other requirements, was consideration must move from the promisee, which is the claimant, and looked at the case of Tweedle and Atkinson, 1861. We went on to one of the other requirements, which was looking at where consideration must be legal. And then we looked at another requirement where consideration must be requested. Again, we looked at consideration must be sufficient. We looked at the case of Thomas and Thomas, 1842, in regards to consideration, and Chappell and Nestle, 1960. We also looked at the leading case of White and Blewett, 1853. We then went on to look at how consideration must be sufficient, and the famous case of Combe and Combe, 1951. We went on to look at the performance of existing duty and public duties. We looked at performance of existing duty with reference to Stilk and Myrick case, 1809, and Hartley and Ponsonby, 1857. We looked at the performance of existing duty and with reference to cases such as like Shadwell and Shadwell, 1890. A lot of these cases are available for you as additional reading on Moodle. So now we're going to carry on from learning outcome 2 to doing learning outcome 3, which is to understand contractual terms and exclusion clauses. Learning outcomes. So we'll be firstly looking at analysing the difference between a condition and a warranty, using cases to exemplify the analysis, explain how terms are implied with contracts, explain the importance and methods of incorporation, and assess the importance of construction for the interpretation of the contract. So firstly, we're going to look at 3.3, which is to analyse the difference between a condition and a warranty using cases to exemplify their analysis. So firstly, we'll be looking at a condition. So a condition, as it is stated, is a term is a major term of a contract which goes to the root of the contract. In a sale of goods contract, this might include a clause that states that the time is of essence. For example, it is a condition of the contract that goods must be delivered by a specific period of time. If a condition is breached, the aggrieved party has the right to treat the breach as repudiated, which means that the aggrieved party can either terminate the contract or treat the contract as continuing, which is to affirm the contract. In either case, the aggrieved party can claim damages. It's important to note that a breach of a condition entitles the aggrieved party to terminate the contract regardless of the nature or consequences of the breach, even if the aggrieved party was suffered little loss as a result of the breach. If a condition is breached, the innocent party is required to repudiate, as we mentioned, the claim. And the famous case in regards to this was the Poussard and Spears case, 1876, where Madame Poussard entered a contract to perform as an opera singer for 3 months. She became ill 5 days before the opening night and was not able to perform the first 4 nights. Spears then replaced her with another opera singer. It was held that Madame Poussard was in breach of the condition, and Spears were entitled to end the contract. She missed the opening night, which was the most important performance as of all the critics, and publicity would be based on this night. So in regards to that, you know, she was liable in regards to that. And in regards to the next element, it's warranties. So warranty is a term of the contract which is less significant than a condition, which is usually written as an assurance or a promise. For example, in a services contract, there might be the requirement to have staff trained at a specific level. If breached, it would deprive the aggrieved party of the whole of the benefit of the contract. A term that is a warranty in one contract might be a condition in another, depending on how important the term of the parties is. Statements about factual matters are commonly expressed as warranties in a contract. For example, a party might warrant that it has obtained all required consents at the start of the contract. Such a statement is likely to be accepted as a warranty, subject to the below. A case in regards to a warranty is the case of Bettany and Guy, 1876. In this case, Bettany agreed by contract to perform as an opera singer for a 3-month period. He became ill and missed 6 days of the rehearsals. The employer sacked him and replaced him with another opera singer. It was held that Bettany was in breach of warranty, and therefore the employer was not entitled to end the contract. Missing the rehearsals did not go to the root of the contract. So it's really important within a warranty that it goes to the root of the contract. And if a warranty is breached, they may be innocent party may be able to claim damages, but not end the contract. So you need to bear that in mind when looking at conditions and warranties. So a comparison chart, the meaning. So condition is a requirement or event that should be performed before the completion of another action is known as a condition. A warranty is an assurance given by the seller to the buyer about the state of the product, that prescribed facts are genuine. What is it? So it is that a condition is directly associated with the objective of the contract. A warranty is a subsidiary provision relating to the object of the contract. A result of breach is a termination of contract for a condition. A result of breach for a warranty is a claim for damages. Violation of condition can be regarded as a violation of a warranty. In a condition, in a warranty, violation of a warranty does not affect the condition. The remedy available to the aggrieved party on the breach is for the condition is to repudiate the contract as well as claim damages, and for the warranty is to claim damages only. As we mentioned, to conclude, a condition is an essential term in a contract or sale and is seen as being of such importance that it goes to the heart of the contract. A condition is a key element that defines the rights and obligations of the parties involved. Should there be non-performance of a condition and the condition is breached, as we mentioned, the innocent party is entitled to treat the contract as being an end and to additionally claim for damages suffered. Whereas a warranty, though still a term of the contract, is not as important as a condition. Warranties typically provide additional assurances, as we mentioned from the comparison chart, or guarantees regarding the quality, fitness, or performance of goods. They typically act as a means to protect the buyer and offer compensation in case the goods do not meet the specified standards or requirements. A breach of warranty in a contract will only allow the innocent party, as we said, to claim damages, but will not terminate the contract altogether. If you are in the process of agreeing terms and conditions with another party, be really clear on what the fundamental parts of the agreement are, and know what may happen should that be a breach, either a warranty or condition. This means knowing both the consequences of a breach of warranty or condition and the remedies for breach of a warranty or condition. So it's really important that you know that before you enter into a contract. So now we're going to look at 3.2, which is to explain how terms are implied within contracts. Express and implied terms. So the terms which parties explicitly include in a contract are known as express terms. If the intentions of the parties are not clear from the express terms, it may be necessary to imply terms into a contract. Contract rarely stands alone in absolute isolation. It may arise out of a particular cause of dealing between the parties. It may relate to a particular set of circumstances or be in relation to a type of transaction which always has certain rules attached to it. In any of these situations, a contract might not expressly include all of the terms that relate to it. Therefore, it may necessarily be necessary to incorporate implied terms. So when you you're asked to sign a contract on behalf of your business, you'd think it would be reasonable to assume that the contracts are, all in place and the contracts contain both express and implied terms. If we looked at express terms, it explains what they are and it's usually in writing and it can be verbal. Contracts terms implied by statute. Traditionally, legal statutes had little impact on a contract freely entered into. However, increasingly terms are implied by statute, which may take precedence to the express terms of the contract. For example, a landlord and a tenant may agree that by way of a deposit, the tenant will give the landlord a painting. The tenancy agreement may include an express term stating this. However, according to the Housing Act 2004, a deposit in relation to a short-haul residential tenancy must be in a monetary form. This law may override the express term in the contract. A common type of contract which is likely to contain terms included by statute is a contract for the sale of goods. Under common law, the legal principle of cover, emptor, or let the buyer beware applied to most contracts for the sale of goods. This meant that it's up to the buyer to make sure he knew what he was buying. Contract terms implied by statute. Today, various terms are implied into most contracts for the sale of goods. Some of the most important implied terms is that the seller has good title to the goods. For example, he actually owns them. Secondly, is that the goods correspond to the description given by the seller. So it's really important that what you're selling is actually identified as given, in regards to that. The goods will reasonably be fit for the purpose for which they are sold and satisfactory quality. So if you're buying a Hoover, you expect it to, hoover your carpet and clean everything up, not expect it to not do that. So where a large quantity of goods is purchased following production of a sample, all of the goods will be of the same quality as the sample. So everything should literally be the same. Whether or not the parties can include a valid express term, excluding the terms which would otherwise be implied by statute, may depend on the number of factors. These could include the previous business relationship between the parties, the relative bargaining power of the parties, and the particular term which is sought to exclude. Contract terms implied by customs. So some contracts may be entered into the context of widely accepted business practices, common to all contracts of that type. Therefore, even if the contract does not include an express term that the practice applies, it may be implied that it does. If the parties decide that the practice or custom will not apply, they may have to include an express term excluding it. If the parties have included an express term excluding the usual practice, this should usually take precedence to the general custom which applies to that sort of contract. Contract terms implied by courts. The courts may imply terms into a contract to give effect to the intentions to the contracting parties. Generally, a court will only imply a term into a contract where it's obvious that it represents what all the parties intended when they entered into the agreement, and where the term is necessarily to give business efficiency to the contract. The courts may also imply a term into a contract if it is necessary to do so for the contract to comply with common law. However, for many modern contracts, the necessary term may already have been implied into the agreement because it is contained in a legal statute. So just to conclude, express terms are the explicit and overt stipulations the parties lay out in a writing or orally during negotiations that form part of a final contract. Express terms can cover a wide range of topics, as we mentioned, including the scope of work, payment terms, delivery schedules, and any specific warranties or guarantees provided. They form the backbone of the contractual obligations and are designed to leave no doubt about the parties' intentions. Now, if some examples of express term is a contract for the construction of a commercial building may expressly state that the structural specifications required. The payment terms, so an agreement between a supplier and the retailer, may specify that payment will be made within 30 days of the receipt of the goods. And delivery schedule, so a manufacturing company might deal the exact dates and specific quantities of products which are to be delivered. And these are some examples of express terms. If one party fails to fulfill its obligation as outlined in the express terms of the contract, it's considered a breach. This breach can lead to legal consequences, including potential claim for damages, an injunction, specific performance, or other remedies, as the case may be. The clear-cut nature of express terms makes it easier to establish whether a breach has occurred and what remedies are appropriate. So that's just to conclude in regards to express term. Now, to conclude in regard to implied terms, unlike express terms, implied terms are explicitly stated in the contract, but nonetheless deemed part of the contract. These terms are inferred based on factors such as the nature of the transaction, industry, customs, statutes and regulations, and the party's intention. Implied terms can be crucial for actually maintaining fairness in contractual relationship. Some examples of implied terms are duty of fidelity. So when in an employment contract, as we mentioned, there's an implied term that employees will act in the best interests of the company and avoid any sort of conflict of interests. The next example is minimum wage. So in an employment relationship, there's an implied term that the employer will pay the employer at least the statutory minimum wage. And another example is terms implied by statutes, as we mentioned earlier. Various laws such as consumer protection regulations can impose implied terms on contracts to safeguard the rights of certain groups, as we mentioned earlier. If you breach an implied term, it can be more complex to establish than a breach of express term, because the relevant term may not be immediately obvious, and it may be necessary to interpret the context and intentions of the parties. However, it can be demonstrated that the implied term was breached. Legal remedies still will be pursued in a similar way as for the breach of an express term. It's really important to understand, whether a term is express or implied. However, the distinction isn't always straightforward, as an implied term can vary depending on the factors such as industry customs, as we mentioned, the nature of relationship and the specific circumstances of the deals. Sometimes you may wish to exclude all implied terms, which will be possible in certain business to business contracts, depending on the circumstances. And that's why it's really important when you're looking at express and implied terms, it's really important that you seek legal advice when actually drafting or interpreting or enforcing any sort of contractual terms and conditions, because it's a really important step to take into account. So now we're going to go on to look at 3.3, which is explaining the importance and methods of incorporation. So incorporation of terms. Incorporation of terms in English law is the inclusion of terms in contracts formed under English law in such a way that the courts recognise them as valid. For a term to be considered incorporated, it must first fulfil 3 elements and 3 requirements. Firstly, the notice of the terms should be given before or during the agreement of the contract. Secondly, that the terms must be found in a document intended to be contractual. And thirdly, that reasonable steps must be taken by the party who forms the terms to bring it to the attention of the other party. The rules on incorporating terms in English law are almost all at common law level. So notice. So for a term to be considered incorporated into a contract, notice of that term must be given before or during the time of the contracting. And the leading case for that is the case of Ollie against Marlborough Court Hotel, 1949. So the facts of this case, that was Ollie was a guest in the defendant hotel. On arrival, Ollie paid for a week's board in advance and then went to the room. In the room, a notice was displayed stating the proprietors would not be responsible for any items lost or stolen unless handed to them for safekeeping. Ollie left the room and deposited her key on the board in reception before leaving the hotel. The key was taken and several items were stolen from her room. Ollie sought damages in negligence. The issue that was addressed in this case was that Ollie contended the hotel was negligent in failing to appropriately safeguard the keys to guest rooms. She further claimed there was an implied term within the contract between herself and the hotel that they would take reasonable care of her property in her bedroom. Ollie inserted the failure to supervise the keys amounted to a breach of that contract. The hotel argued that guests were bound by the terms displayed on the notice in the bedrooms, and therefore the hotel had effectively excluded liability even if they had been negligent. The notice was clearly visible in the bedrooms, and the exclusion clause unambiguously absolved the hotel of any liability for stolen items. The hotel also argued that Ollie had been contributory negligent by depositing her key on the board in the reception. Now, the decision and the outcome in the case was that Ollie was successful in her claim and recovered the cost of her stolen items in their entity. The exclusion clause had not been successfully incorporated into the contract because the contract was concluded at reception and the notice perpetrating to exclude liability was not visible until after the contract was formed when the guest entered the bedroom. So in that case, Ollie was successful in her case. An exception to the rule on the notice is past dealings. If the parties had similar dealings in the past, the courts have previously found that notice is not necessarily required if their past dealings represent a consistent course of action. Again, the case of Ollie and Marlborough Court Hotel. Incorporation of terms, contractual document. The second rule required for clauses to be considered is incorporated as is that they must be found in a document intended to contractually binding. So there must be a contract in place that's contractually binding. And the case in regards to this was the case of Chapelton and Barry Urban District Council 1940. And I'll go through the facts of this case for you. So Chapelton in this case wished to hire a deck chair and approached a pile of chairs owned by Barry Urban District Council, BUDC. A notice adjacent to the chairs detailed the cost of the chair, the cost of hire, and advised customers to obtain tickets and retain them for inspection. Chapelton purchased tickets and placed them in his pocket. On one side of the tickets, the council perpetrated to exclude liability for any accidents caused by hiring the chairs. Chapelton sat down and the canvas gave way. He sought damages from BUDC and it was held that they had effectively excluded liability. And then Chapelton appealed. The issue in this case was that Chapelton argued that he had not been given sufficient notice of the clauses printed on the ticket, and therefore he should not be bound by them. There was nothing on the notice adjacent to the chairs or on the face of the ticket to alert customers' attention to the clauses on the back. The ticket should be regarded as a receipt provided after the formation of the contract. BUDC contended Chapelton did have notice of the terms because the exclusion clause was clearly printed on the ticket. The notice adjacent to the deck chairs was merely an invitation to treat. The ticket was not merely a receipt, but it amounted to a written contract detailing the terms by which the parties agreed to be bound. The decision in the courts was that Chapelton's appeal was successful. The ticket was held to be a receipt, and the conditions by which BUDC were held to have offered the chairs for hire were those contained in the notice. the notice did not contain any exclusion clause. BUDC had not, therefore, brought Chapelton's attention to the clause, and they could not rely on it in this case. When considering any sort of factors, it's really important that you take two elements into account. What the document is called is not conclusive. The document does not have to be specifically identified as a contract. And secondly, the document must be delivered before the contract or at the time of the contract. So if one signs a contractual document, it's automatically considered to be binding, even if the party has not read the terms. And this was the case this occurred in the case of LO3 and Grogum Limited, 1934. And in this case, the facts was that the claimant, LO3, contracted to purchase a slot machine for cigarettes from the defendant, Grogum, and the agreement included an express clause stating that this agreement contains all the terms and conditions under which I agree to purchase the machine specified above, and any express or implied condition, statement or warranty, statutory or otherwise not stated, herein is hereby excluded. The machine proved to be faulty, and the claimant thus brought an action against the defendant, alleging that the machine breached the Sale of Goods Act by not being of merchantable quality. The defendant asserted that the statute was made irrelevant by express clause and that he was not in breach of the agreement that had been made. The claimant responded she had been unaware of the clause, as she had not properly read the agreement and it ought not apply. The issue in the case was whether the clause excluding all terms not stated in the contract should be deemed effective and binding. It was held in this case that the Court of Appeal found for the defendant, determining the express provisions of the contract were binding and effectively excluded the relevance of statutory sales provisions. Furthermore, the fact that the claimant had not properly read the contract did not impact its validity, as in signing the contract, she consented to be bound by its contents. Significantly, this case emphasizes the court's respect for sanctity of the contract. Also, looking at reasonable notice is an objective consideration of whether the party is subject to the terms. Are they aware of them? There's no requirement as of the terms in regard to that. And in regards to that attention of the other party, so the third rule required is that considered incorporated as reasonable steps, so it must be taken by the party who forms the term to bring it to the attention of the other. So the case in regards to this was the case of Parker and South Eastern Railway Company, 1877. In this case, Parker paid to leave his bag in the cloakroom of South Eastern Railway, SER. There was a notice within the cloakroom stating that South Eastern Railway would not be responsible for any deposits exceeding £10 in value. The tickets given to the customers on making their deposit had same notice printed on them in legible writing. Parker's bag exceeded £10 in value and it was lost or stolen. Parker successfully claimed against the South Eastern Railway for his lost bag, and South Eastern Railway SER appealed. The issue in this was that Parker argued that he had not seen the notice in the cloakroom and had not read the terms on the ticket, but had simply placed it in his pocket, believing that it to be a mere receipt for his deposited goods. As such, SER should not be able to rely on exclusion clauses because it would be unreasonable to expect customers to know that a receipt for deposited goods contains special conditions. SER claimed it was irrelevant whether Parker had read the notice or the ticket because a party could still be bound by contract irrespective of whether he had read its terms. They argued that they had taken sufficient steps to bring the terms to the customer's attention. The decision by the courts was a retrial was ordered. The judge's direction at first instance that Parker was not bound by terms he had failed to read was incorrect. Parker would not be bound by the terms he did not know that were printed on the ticket, but where he knew there were terms on the ticket or that there was writing on the ticket, he would be bound, providing the jury was satisfied he had been given sufficient notice. If a notice of the term is displayed on the contractual document, this is normally sufficient. And the leading case of this one is highlighted in the case of Thomson, London against London, Midland and Scottish Railway Company Limited, 1930. The objective consideration is highlighted in this case, where it was held to be irrelevant that the individual was illiterate. If this fact is known by the party supplying the document with the terms, it was, for example, plainly obvious that the individual was blind, the term would not be incorporated. Terms can also be incorporated by referring the party to a different document, which has the terms in Thomson and London, Midland and Scottish Railway highlights that the ticket stated subject to the conditions set out in the timetables. Although the actual contractual document did not have these conditions in, the reference was enough to objectively incorporate them. The next one is a rule is the more exceptional or unusual a term is, the more it must be done to bring it to the attention of the other party. And in order for the terms to be incorporated by reference, as we mentioned in the case of the next case, which is Sperling and Bradshaw, 1956. In this case, Bradshaw sent 8 barrels of orange juice to be stored at Sperling's warehouse. Sperling sent a receipt to Bradshaw on which were printed their conditions of storage. The conditions contained a clause perpetuating to exclude liability for any losses resulting from their negligence. Bradshaw fell into arrears with his storage payments, and Sperling brought an action to recover the monies due. The orange juice was spoiled and unusable, and Bradshaw counterclaimed in negligence. Bradshaw alleged that Sperling were negligent and in breach of an implied term to take reasonable care of the barrels because they had left them in the open air and the orange juice had spoiled. He further contended that he had not given sufficient notice of the exemption clause and therefore Sperling should not be able to rely on it. Sperling denied negligence and argued they could rely on the exemption clause even if they had been negligent. The clause had been brought to the attention of Bradshaw and was clear and unambiguous in its meaning. And it was decided in the courts that although it had not been proven that Sperling had been negligent, even if they had been negligent, they would be able to rely on the exclusion clause to avoid liability. Sufficient notice of the clauses had been given so as to make it a term of the contract. Exception clauses will operate to protect a party only where he is carrying out his contract and not where he is deviating from it in a fundamental respect. So in order for the terms to be incorporated by reference, the document referred must be readily available. In another case, which is the case of Sterling Hydraulics Limited and Dixmatic Limited 2006, a term referred the party to the general terms of a sale. However, these terms of sale were not sent with the contractual document, therefore they were not incorporated. Another case in regards to unique circumstances of incorporation and notices relates to ticket machines is the case of Thornton and Shoe Lane Parking Limited, 1971, which it affirmed that the fact if the terms of a contract are included on a ticket which is printed after the money has been paid, the contract has been formed already and therefore the terms are not incorporated. Following the terms relating to contracts through automated machines must be made clear before the ticket has been purchased, perhaps by a sign or another form of notification. Now we're going to move on to 3.4, which looks at assessing the importance of construction for interpretation of a contract. So construction interpretation determine the true meaning of intent of contractual terms, and they provide the framework for resolving any sort of disputes and guiding the parties. The contract must read as a whole, not a series of isolated parts, and it must be read with an attempt to give reasonable meaning to each provision, and no provision in the contract can be arbitrarily regarded as meaningless. So if you look at this diagram, it identifies the starting point here, which looks at the actual words used. If the meaning is unclear, then it would go down to the bottom. So resolve doubt against benefiting party. Are the words part of the common category? If the meaning still unclear, the court may rely on terms. Reasonable and equitable goes down. Obvious or necessary to given business and does not contradict express terms and capable of clear expression. The starting point, what is the ordinary and natural meaning of the word? Set against background and commercial, refer to any established judicial interpretation, and is there any specific technical scientific meaning? How courts interpret contracts. So factors that the courts will consider is the natural meaning of the words used, the contract as a whole, maybe the commercial common sense and factual matrix. They will also consider things like evidence of subjective intentions, how the contract was performed, so the way the contract was performed, and pre-contract negotiations and hindsight. Importance of construction in contracts, so natural meaning versus commercial common sense. So at one end of the spectrum, there's the view that the court must apply the natural meaning of the words unless there's lack of clarity or an ambiguity in the language used, or it would produce an absurd result. Then and only then can the court adopt the construction which is most consistent with commercial common sense. And commercial common sense is some words and phrases have to acquire an accepted legal sense through decided cases. Good examples are phrases such as best endeavours or reasonable endeavours. At other extreme, there's a view that commercial considerations may indicate a lack of clarity or ambiguity in the first place, and that any arguable construction must be tested against commercial common sense. Recent judgments seem to indicate a trend towards greater emphasis on the language used, with higher courts generally seeking to downplay considerations of commercial common sense unless there's some ambiguity or lack of clarity. The courts will take into account commercial common sense when interpreting a contract. In recent years, there's been a shift, as we just mentioned, in an emphasis in the importance of common commercial common sense when interpreting contractual terms. However, the Supreme Court has now made it clear that the starting point is the natural meaning of the language used. Commercial common sense cannot be relied on to undervalue the importance of language of the provision which is to be construed. Courts will be slow to reject the meaning of the provision simply because one of the parties made a bad bargain. It is not for the court to improve the positions of the parties by rewriting the contract. However, where there is ambiguity and more than one possible construction, the court will select the interpretation that makes the most commercial sense, the presumption being the parties would have intended a commercial result. Bad drafted contracts. So a court is likely to have greater regard to commercial sense as other parties from the actual words, as we've just mentioned. The best way to guard against disputes about proper interpretation of contracts to ensure that all clauses are carefully drafted, looking out for areas of potential ambiguity and paying close attention to correct punctuation and grammatical structure. Particular care should be taken with defined terms and formulas, as these are common areas for problems to arise. Where additions or amendments are made, these need to be checked carefully to ensure they are clear and consistent with other provisions. Exclusion of pre-contract negotiations. Courts will not admit evidence of the parties' pre-contract negotiations for the purpose of interpreting a contract. However, such evidence may be admitted to show that a relevant background fact was known to the parties, and so should be taken into account as part of the factual matrix. The exclusionary rule means that evidence of the parties' subjective aims and intentions will not be admissible for the purpose of interpreting the contract. The rule does not, however, exclude such evidence for other purposes. For example, to support a claim for rectification, which is that the written contract should be corrected because it does not reflect the terms actually agreed. And secondly, estoppel by convention, for example, that the parties will have negotiated an agreement based on some common assumption. Limiting the factual matrix. It is sometimes argued that admitting evidence of factual matrix is unfair to the third parties who might be affected by a contract, as it increases the risk they may find the contract does not mean what they have thought it meant. The fact that a contract might affect a third party, such as an assignee, is not normally sufficient to prevent the court admitting background factors known to the original parties. However, where a contract is of type that is treated as addressed to third parties, which is, for example, the Articles of Association, the courts may restrict the admissible background to the facts which have been available not only to the contracting parties but also to the relevant parties. The role of factual matrix may also be more limited in contracts concluded on industry standards, given the particular need for commercial certainty in that context. Limits of commercial common sense. So while interpreting a commercial contract, courts will assume that the parties intended their agreement to make sense in the commercial context which prevailed at the relevant time. However, that does not mean that commercial common sense can necessarily be invoked to prevent the court interpreting a clause in a way that makes little commercial sense for one or other party. In addition, commercial common sense cannot be invoked retrospectively, so it's only relevant to the extent it sheds light on how matters would or could have been perceived. It can sometimes be difficult for judges to block out entirely the knowledge gained through hindsight. Contract as a whole. So in interpreting a term in a contract, the court will not look at the clause in the isolation and will interpret by reference to the contract as a whole. The positioning of a term within a clause or within the contract overall may be important. Parties should pay close attention not just to the wording of the clause. If a clause appears in a section of the contract relating to one issue, It may be difficult to persuade a court that it is meant to deal with another issue, even if the wording of the clause might be broad enough to cover that issue. If, in the instance that the contract is part of a series of interrelated agreements, then the court will take into account not only the contract in which a clause appears, but the overall scheme of the agreements. Tools of construction. Where there is some doubt or ambiguity as the meaning of the contract term, it should be construed against the party that has put forward the clause or is seeking to rely on it. This is known as a contra preferentum rule, where there's a list of examples together with general wording. The general wording may be interpreted as limited to other examples of the same type. This is the estudio generis rule, meaning of the same kind. Where particular objects, rights, or powers are expressly mentioned, this tends to suggest that other similar objects, rights, or powers are not meant to be included. This is known as expressio unies. In general, the court would prefer an interpretation which gives effect to the contract or the particular clause rather than one that renders it ineffective or meaningless. Similarly, it would generally prefer an interpretation that does not allow one party to take advantage of its own wrong. When we're looking at in regards to the courts in the UK, the English courts, in conclusion, the English courts sometimes employ certain, like we said, canons of construction or rules of thumb in an attempt to do justice between the parties. However, these principles are just pointers, and the court will only resort to applying them if the meaning cannot be found using the general rules of interpretation. So firstly, the courts will clear words. The court will be reluctant to adopt a meaning that gives an unfair result in the absence of clear drafting. For example, the courts have held that unambiguous language is required to exclude certain contractual remedies, as mentioned earlier. Another one is the courts will resolve any uncertainty or doubt surrounding a provision against the party who would benefit from the suggested interpretation. And then where the presiding words are part of a common genus, as we mentioned, or subsequent. Ultimately, and in conclusion, the rules of construction are no more than guidance tools, and the particular facts and circumstances of the case determine how they are applied. In practice, it is open to judges to select, from those tools as at their own discretion in order to make the contract work, give it that effect to the parties, which is presumed effect, and intentions, and to try to achieve a reasonable justice between them. So we've finished learning outcome 3 now, in regards to looking at the element of understanding different contractual terms and exclusion clauses, looking at implied express terms, looking at the cases in regards to it, looking at the wording of the contract, incorporation of terms, looking at the elements of how a term becomes the wording of it in regards to court's discretion. We've now finished, and the references are listed just below in regards to what we've used for this session, which are Anson's Law of Contract, Studies in Contract Law by Ailes, Beale Contract Law, Collins, The Law of Contract, Undue Influence by Hart, Concept of Law, Kendrick. So these are a list of all the resources we've used for Learning Outcome 3. Make sure that you go on to Moodle to get any sort of additional reading, and some of the cases are on Moodle as well, so that you could refer to when completing your assignment. The next Learning Outcome we'll be doing, which is next week, we'll be Learning Outcome 4, and then the other ones after that. So thank you for attending today's session, and thank you for listening to me today. Thank you.